What happens when you're told that DEI is illegal discrimination? What happens when you've been told this year after year after year after year? It makes white people think that it's okay to sue for anti-white, anti-straight discrimination. Yes, those words actually came out of my mouth. And no, anti-white, anti-straight discrimination is not a thing. Sorry. But according to the Washington Post, CNN, and NBC News, white, straight Marlene Ames from Ohio claims that she faced anti-straight discrimination in the workplace. She filed a job discrimination lawsuit in 2020 after she was removed from her job as an administrator at the Ohio government agency overseeing juvenile corrections. Her position was given to a younger gay man. Ames said she was also unfairly passed over for another management role, which went to a woman who Ames considered to be less qualified. The woman it went to is a lesbian, and Ames said this woman had not initially expressed interest in the job. Maybe she expressed interest in the job later on. We don't know. We don't know her life. Now, the state says that Ames was demoted because new leadership in the agency wanted to restructure its operations to prioritize sexual violence in the juvenile corrections systems. Ames led a program aimed at combating violations in prison, but was seen as difficult to work with. Okay. Now, this is according to the state's court papers. Officials involved in making those decisions were straight. Yeah. But Ames brought a claim against the Ohio Department of Youth Services under the, I think it's Title 20? I think it's Title 20 of the Civil Rights Act, which prohibits sex discrimination in the workplace. Now, Ames and her lawyers are challenging a requirement applied in 5 appeals courts across the nation that majority Americans raising discrimination claims must demonstrate background circumstances in order to pursue their suit. A plaintiff might meet that requirement, for instance, by providing statistical evidence documenting a pattern of discrimination. Now, the majority is straight white people. And to my knowledge, there is not a pattern of discrimination against members of the majority, straight white people, because the majority is usually the one doing the discriminating. Ames could not show a pattern of discrimination against the majority, straight white people, so she lost. Okay. Now, I want to note here that an employee who is a member of a minority group does not have to face that same hurdle. They don't have to prove a pattern of discrimination, okay? Because the pattern of discrimination is, well, obvious. Lower courts, including the Cincinnati-based 6th U.S. Circuit Court of Appeals, ruled for the state agency. They sided with Ohio, okay? Ames turned around and took it to the Supreme Court. The case landed on the Supreme Court's docket last fall. The Supreme Court appeared virtually certain to side with Ames. There was broad agreement in the courtroom during oral argument, even from the lawyers representing Ohio officials, that the rule is not consistent with federal employment law. So it's requiring one group of people to do something that another group of people don't have to do. The ruling could be unanimous based on the questions asked by conservatives and liberal justices. It doesn't matter if she was gay or whether she was straight, she would have the exact same burden and be treated the exact same way, Justice Amy Coney Barrett stated. Justice Neil Gorsuch appeared to agree. He noted that there was radical agreement in the courtroom, meaning that all the justices seemed to agree. Justice Sonia Sotomayor indicated Ames may have a valid claim, saying there was something suspicious about what happened. Was there, though? Was there? Because we don't say there's something suspicious when consecutive white people get promoted over people of color or over LGBTQIA people. They don't say that then. It appears likely that the court will send the case back to lower courts for further litigation on whether Ames's case can move forward. If the court rules in Ames's favor, it could affect workplace discrimination claims of all kinds. For example, it could make it easier for white people to claim they face racial discrimination as a result of diversity, equity, and inclusion, DEI. You know, the thing that's become a four-letter word. Fun fact, America First Legal, a conservative group with close ties to the Trump administration, filed a brief in Ames's case, citing cases it has brought against various companies, including Starbucks and IBM, and a small black-owned company. Black women own this company and give out grants to other black women starting businesses. Yeah. They file cases alleging race and sex discrimination.